So yeah, basically we're here today to just give you all a really good overview, hopefully, of what mooting is and the kind of procedure and etiquette and how to write a moot, that kind of stuff. So this is the basic outline for today's lecture. No, it's not a lecture. You can put your hand up and everything, but we will have questions at the end.
Yeah, if anyone has questions as we're going through something, it's useful if you ask it, just chuck your hand up and ask it straight away, because obviously everyone will know what it's related to then. But equally, if the moment's gone, you're welcome to note the question down, and at the end we'll just have an open session where you can ask anything related to mooting.
And I mean, a few of you will just have absolutely no clue what mooting is. A few of you might have done lower level moots or some of the competitions and things. So we're just trying to cover all the bases to get everyone on the same page. But, you know, if you have a really basic question, don't be afraid to ask. Cute. Oh, we didn't take this out. So if anyone watches Suits, this is a little in-joke, which James is probably...
I didn't include it, though. We had to heavily edit the presentation to remove previous Suit references from the guys who did this presentation last time. So it's better now.
All right.
Okay, so first of all, for people who have absolutely no experience whatsoever with mooting and you don't know what it is, in essence, mooting is replicating a court scenario, a courtroom scenario. So it's representatives of two parties in a courtroom arguing on a point of law and the application of that law to the facts in a particular case that you get given. So these are hypothetical cases that you get given, and then you're applying the law to those cases. In terms of the moot itself, your job is to submit on those issues. So you're in the courtroom on behalf of your client arguing for their case, and so trying to ensure that the finding is in favour of them. And those submissions comprise both written submissions, so before the moot you submit written submissions, although for those doing the Torts Moot, that's not necessary for that particular moot, but generally there will be written submissions, and then oral submissions, which is the actual courtroom scenario where you're making them to a judge. The problems, as it says, explore complex legal issues, but sometimes, don't let that put you off getting involved in mooting. And at their essence, they're often actually quite simple. There might be kind of complex application of those issues or something like that. But often when you drill down to the heart of a legal issue in a particular case, it becomes quite simple. And also often it becomes not just a question of law, and so what the precedent from previous cases has been, but also a question of policy. So what would be best for the world or for a particular area of society, which type of law and which application of that law would be best. And that's because usually moots are at an appellate level. So often they're in the Moot Supreme Court of New Zealand, so a hypothetical Supreme Court, which means while precedents are influential and guiding, they're not necessarily binding, which means that you can introduce some of those policy arguments and say, even if the other party can prove that precedent from previous cases would guide you to do one particular thing, you can submit that it would be bad to do that for policy reasons, and we'll get into the nuts and bolts of that a bit later. The final point to note there is that mooting is really valuable, and as much as possible we'd encourage you to take opportunities to get involved in mooting, both in terms of making the most of the opportunities within your courses to do it, but also outside those courses we run a number of competitions, and it does really, for me, the areas where I've felt most comfortable going into exams in terms of the content have often coincided with the areas that I've mooted on, because you gain a new understanding of how the law actually works in real world scenarios when you're forced to confront it, and when you're forced to think about all the different possibilities that one argument on a piece of law could mean in terms of the implications when a judge is asking you, well, what about if we were to apply that approach in this scenario? So it just really does force you to understand the law in a much deeper way, and obviously also improves your communication and presentation abilities, which is important for lots of areas of legal practice, but also the transferable skills to other career pursuits that you may have.
So, What mooting isn't? Mooting is not just giving a speech. It's not reading off a piece of paper of points you've written down. It's essentially, which we'll come to talk about a little bit more, it's a discussion with the judge. The judge wants to hear you convince the court why your client should succeed, why they should find in favour of your client. And they want to challenge you and try to get to the bottom of the issue by sort of having that two-sided discussion. So that's why they ask you questions. It's not a debate. So if you've done debating before, we were both saying before, it doesn't give you an advantage. Sometimes it can be a disadvantage. James was a debater. I've never done a debate in my entire life before I tried mooting. Didn't even know what mooting was before I did the junior moot last year. So it's neither an advantage nor a disadvantage. I think, you may be more comfortable, more familiar with public speaking, but often debaters can be a little bit more aggressive.
So much shade.
Aggressive and fast talking. So I think what we're trying to say here is that mooting is open to everyone can do it, everyone is able to develop that skill set because it's independent of anything else you might have tried before. All right, just a little note there, in terms of competitions and relevant to your torts moot, the actual oral presentation won't do the entirety of the marks, and you do have to make sure you make coherent legal arguments and back it up with relevant case law.
I think what that represents is that when you're submitting orally, the judge, so there's a tendency to feel that if you stumble over some of your words and things like that, that's going to cost you. And it might, to some extent, it might make up 25% of your marks. But the judge really wants to know, do you actually understand the law that is being discussed here, and are you applying it in a way which is consistent and correct? And can you carry out that analysis consistently in other scenarios and things like that? So if you're generally as a speaker kind of quite stunted in terms of how you speak, or if you're not particularly fluid with your speech, if you're not that stylistic, that does not hold you back in mooting, and often the best mooters are people who are quite reserved, very slow in their speaking, and so that's fine, and don't feel as though that could be a barrier to you doing well in mooting.
Cool, so we'll move on to preparation. Okay, so as every lecturer will tell you, read the problem and read it very, very carefully, especially for things like your torts moots, but also in any competition. Usually it's going to be, you're going to be appealing a decision, and they'll give you some information on what's been decided in the lower court, so you definitely want to reference that in whatever your argument may be for your client. So as you would in any problem, with an exam, anything you do in law school, identify your arguments and counter-arguments, read it again, go over it in more depth, and make sure you know all the facts really, really well. So the judge will try to take you to the side of what your argument might be, try to put it in new context. So if you know the facts really well, then you're able to sort of stretch your thinking a little bit more easily, and it won't sort of unsettle your understanding. Identifying areas of uncertainty is a really good thing to do as you're going through and working through the problem. So your issues are going to be your main points that you submit on. But you want to just note down little areas where it's ambiguous, where it could go either way, because that is what the judge is going to pick up on and question you on, and where you actually have to argue your case mostly. Seems like a basic point, but again, make sure you know which side you're on. Make sure you know what you want the outcome to be for your client, because it's great to do that at the very outset, because then you can focus all of your reading, all of your case analysis, and trying to support that point and that outcome.
Okay, so you've read the problem, and then you come to the cases. So in the moot, in the torts moot, which I imagine a number of you are doing this year, that does not give you a case list, as far as I know, for your particular moot. So you're required to do the research. Generally, the cases that you're going to be wanting to, first of all, look at are cases from the higher courts, so Supreme Court and Court of Appeal. And that's because those courts naturally, because of their authority, carry more weight in your moot court setting. The one thing to note there is that, I mean, like, research is great, and if you've got plenty of time on your hands and enjoy it, by all means, go for it. Some people, I think, can tend to over-research with these sorts of situations where there's no set list of the cases that you need to rely on. And it'll help you to an extent. So if you're really gunning for that, A+ grade in the Torts Moot, then maybe do that to leave nothing to chance. But by and large, if you have a really good understanding of the main cases that are actually covered in your course, so the stuff that the lecturer describes in relation to the particular area of law that you're mooting on, that will serve you pretty well. And it's unlikely that your tutor is going to, toss up this entirely new case that you've never thought of before, because you hadn't looked that far beyond the course. So, do your due diligence, do a keyword search in the databases just to check there aren't any Supreme Court judgments relating to that issue that your lecturer hasn't yet covered, or that maybe your lecturer skimmed over. But by and large, don't freak out and don't just go crazy with the research. Just be reasonable and, don't destroy your life with research. So as I mentioned before, stuff you've learned in class is key. Legal databases is key, are key. And then beyond the Torts Moot, most competitions that you undertake, so the junior moot, which I imagine a lot of you will be eligible to do this year, that's available for Part 2s in their first year of law school, and the mooting competitions that we run, such as the John Hague Memorial Moot, which is available for students beyond their first year of Part 2. Those competitions will generally provide you with a set list of authorities, so they'll say, these are the cases that you're allowed to use in supporting your argument and researching your argument, and you should, generally that will be described as a closed list of authorities, and if that's the case, that implies that you're not allowed to go beyond that list. So by all means, you're welcome to seek out other cases to try and improve your own understanding of what's in the cases that you're given, but in terms of what you can actually use in formulating your written submissions and when submitting in the moot court to the judge, stick to those cases that are listed, and that is also in your interest, just because it means that you don't spend unnecessary time on cases that won't be relevant when it actually comes to the moot. Read all the cases. It says twice. Probably read them twice. But again, don't freak out. What you need is a good understanding of what the key facts are in each case. And in terms of your research, this is the other thing I would advise. For all of the main cases that you're using throughout your moot, create a brief summary, so maybe 6 bullet points of the facts of that case, and then of the ratio for first of all, the decision, so who that case was found in favour of, and then the ratio for that decision. So it doesn't need to be hugely complex, but just so that you have on a piece of paper for each of the key cases that might come up throughout the moot, a brief summary that you can turn to, because there will be situations where the judge, when you mention a case, an authority, the judge will often say, can you remind me of the facts in that case, counsel? And if you're able to turn and very succinctly describe that, it's much better than if you're kind of umming and ahhing and trying to remember off the top of your head what that case was about. So in terms of the research and preparation, I think that's useful. Generally it'll be quite clear that there are 2 issues in the leave to appeal. You should divide those between each of the 2 people in your team. That's relatively simple. And then the final thing is, as I said, other cases outside that list and outside of the obvious cases are useful to aid your understanding. Commentary and journal articles can also be useful, but those are primarily to aid your understanding rather than to give your argument weight when you're actually in the courtroom. So it's best not to say, X journal tells us that this should be the case, but that can be very useful for understanding why the person who wrote that journal thinks that should be the case, and then you can build those reasons into your policy arguments when you're actually in the moot.
All right, so this is sort of just...
sorry.
It's all right, you just jumped ahead. Elaborating on what you said before, James. Knowing the facts of both your case and anything you cite is really important, especially for things like the Torts Moot. They're probably not going to go super in-depth and challenge every single point of your argument, so really common questions are focused on your supporting cases. What are the facts? How's it relevant? Which court was it decided in? Just having them at hand is a really easy way to get marks and get around that. Again, just back up any statement you make with law. Right, written submissions. So just a reminder, these are not relevant to torts moots, but you need written submissions for every other competition, every other moot, and real life. So basically, written submissions are a really succinct summary of the arguments you're going to make, and it's provided to the judges and your opposition. So in an actual, in the mooting scenario, in a courtroom, in your oral submission, you're actually going to refer the judge to the points in your written submission, so it'll be bullet pointed, submission 1, then 1.2, 1.3, etc., etc., so that they can follow along and so that the other side knows the basic arguments you're going to make. This is not a fully written description of exactly what you want to argue and why you're arguing this. It is simply a sort of a skeleton of your argument with supporting authorities. So as we said, not necessarily for torts, but for competitions, you will usually have a limited number of pages to write your written submissions because I don't want you to just give them a huge wad of paper, and some of your score will be based on these. And
the other thing to note there is, in terms of how that actually manifests itself in real written submissions, we will put on the mooting, or we have put on the Mooting Society website under information resources. Example of, I think, Caitlin's excellent written submissions at the NZLSA National Junior Moot competition. So that will give you an idea of how to format your submissions, and also just the correct level of concision and succinctness. I think that's the main thing to take away, though. Be as succinct as possible. So you basically just want the bare bones of your argument within these written submissions. All of the logical links between arguments and towards your conclusions are what you're submitting on orally when you actually get into the moot itself. The written submissions are just there to provide an outline for the judge to follow along and some indication for the people that you'll be against in the moot of what your argument and stream of logic is going to be.
One of the nice things about written submissions as well, in terms of a competition, is if you know what the other side is going to argue, and usually their basic arguments will already be evident to you from going through your own, you can sort of prepare something to say in return if the judge should question you on what the other side has said. So that's quite often helpful, just to prepare yourself for the actual situation.
The other thing to note there, just quickly, is that when you're preparing your oral submissions, and we will come into this, you can flag something that's been submitted that is directly contradictory to what your submissions suggest. And in terms of how you do that, you would say, my learned friends for the respondent or my learned friends for the appellant, depending on which side they're on, submitted X, and then explain the proposition very briefly, and then explain why, respectfully, you suggest that the opposite is true, and explain the distinction there. So it is okay to have some of what I guess some people would call rebuttal within your submissions. You don't want to go overboard on that, so you don't want your submissions to just kind of be filled with you trying to argue against the other side, because you are advancing a positive case for yourself. But to the extent that there's clear disagreement between basic premises of law and things like that, you can flag those and submit on them, and that will probably push you to a higher grade a little bit as well if you do start to do that. Okay, so finally for the written submissions, so it can be useful if you're the appellant to include a brief summary of facts for the judge. So obviously that should be relatively small. The judge in most competitions will have the summary of facts that the competitors have been given, so it's not overly necessary, but it's useful to have there for kind of clarity's sake. Then for each of, for your written submissions, you should have 2 to 4 key submissions. So these are like basic propositions of law, which those are essentially the conclusions of all of the legal analysis that you're going to undertake in the moot. So the correct test for remoteness is X, and then underneath that, so that's your main submission, and then underneath that you'll have sub-submissions or sub-points of submission, which are essentially the things that came to you making that conclusion, the things that contributed towards you making that conclusion. So various parts of that test that have been built up through different authorities you can mention in those sub-points. But yeah, basically those key submissions are the very highest level of the conclusions that you reach, which contribute to your overall argument that that the court should find in favour of your client.
And just a note on that is that those 2 to 4 key submissions that you have put in your written submissions, they are the basis for your oral argument. You can't just go off on a tangent when you're actually in the room and say, Your Honour, I actually submit something else, blah, 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 because they haven't got anything in front of them and the opposition hasn't had the time to sit down and see that for themselves. So you just got to make sure that you've got it right when you hand in your written submissions.
Yeah. In terms of like the content of those, there's obviously no hard and fast rule, and it will vary between moots, but also between the people participating in the same moot, because it all depends on your strategy for how you want to prove the case for your client. But broadly, I think often these submissions come down to things like, first of all, saying the correct test for a particular part of law is this test and explaining that test very briefly, and then going and then basically a following point of submission, which is the client, say the client's name, that that the respondent did not fulfil the legal definition of assault or something in his actions, or something like that. So essentially, setting out one submission might be setting out what the law is, and then the other, the application of that law to the facts at hand. Similarly, you might sometimes have the preferred test in the law that you think is the correct one, and then you might have an even-if argument. So in the alternative, the court should follow this test, and the respondent should still be found to have not fulfilled the criteria for assault or whatever. So those are kind of the broad types of submissions that you often have. So proposition of law, application of law, in the alternative, proposition of law, and then maybe in the alternative application of that as well. Cool. I think that's everything for written subs.
All right. So just a basic note on oral submissions. As I said before, they're essentially a conversation with the judge. They're having a dialogue, they're asking you questions, and you want to use the arguments that you've put forward to answer those questions. So that will mean that you probably are going to jump around your submissions. And thirdly, be convincing. You are trying to win the case for your client. So use everything in your power to convince the court why you're right and why they should find for your client.
Okay, so we'll just go through the very basic mechanics of a moot here, because often that's the thing that scares people the most. So just like the basics of what do you do in a moot, not how do you make your arguments. Essentially, the way the moot will start will generally, in competitions, and this sometimes varies in torts moots because your tutor might do away with some of the formalities. But generally what will happen is all of the parties will be sitting in the room or in the moot court. The judge will walk in you will bow to the judge, then they will bow back, but it's obviously not like a full bow, it's just like a nod of the head. And then once the judge has done that, they will sit down. Once the judge has sat down, you sit down as well. That's your cue, you're taking your cue from what they're doing. And then the judge will probably shuffle their papers, maybe note a couple of things down, and then they'll gesture to the parties that they will take appearances. So they'll either say, generally they'll just say, "I'll now take appearances." And so then the way that works is that the appellant first stands up and says, so both parties for the appellant, they're senior counsel and junior counsel, they both stand up, and the senior counsel says, "May it please the court, I'm not, but I am Miss Anyon-Peters, and I appear for the respondent with my learned junior Penn." So the key thing to note here, or a key thing to note here, is in some weird relic of the olden days, men just refer to themselves as their last name, so "I am Penn" as opposed to "I am Mr. Penn," whereas women refer to themselves as Miss, Mrs. or Ms. So those are appearances. The appellants stand up and do theirs. They then sit down. Judge will usually say thank you and then look towards the respondents. The respondents stand up. The senior counsel says the same thing for them. And then they sit down. Then the judge will maybe again note the names down, and then will nod at the senior counsel for the appellant, or say, say your name, Miss Anyon-Peters, or just basically gesture something to indicate that they're ready for your submissions. And so you walk up to what will usually be a lectern and start making those submissions. Then, in terms of the basic structure, the senior counsel for the appellant submits first, then the junior counsel for the appellant, and then it flips over to the case for the respondent. The senior counsel for the respondent submits first in that group, and then the junior counsel for the respondent. There's then no rebuttal. Some more advanced mooting competitions, I don't think any of the Auckland ones, but overseas ones sometimes have rights of reply and things like that. That's not the case in any of the competitions that people here will likely be doing. So basically, once the junior counsel for the respondent has finished their submissions, that's it, and the moot is over. Within the moot, it's a relatively formal setting. So instead of using terms like your and their, instead you refer to your learned friends, and you refer to the judge as your honour. Equally, you don't start to integrate language which would generally be described as casual, so no sweet, okay, don't say cool, don't say awesome, all that sort of stuff that just...
I did that in my first book, I said awesome.
Yeah, that's the other thing.
You get a slap on the wrist.
Don't freak out if you do that like a couple of times. The judge isn't going to give you a 50% mark because of it. It's okay. It's just not advised, and if you do it too much, it'll harm you. When you're actually delivering your submissions, you should refer to things that you submit, not things that you think or believe, because it isn't about what you believe. It's about what you're submitting in terms of points of law and what is correct for society or correct for that particular part of the law. So you are submitting. So you say phrases like "I submit" or "it is my submission." But equally, you don't have to start every sentence with "counsel submits this." You can just go straight into the proposition that you're going to make after that. So you can just remove the preposition from that, and use those sorts of phrases relatively sparingly.
Equally, you should respond in that manner when a judge asks you a question. So you can answer it directly, yes, Your Honour, no, Your Honour, etc., why, therefore I submit such and such. Or you can start that way. It's just a term of respect.
I think that's on your next slide, actually.
Is it?
Oh, maybe not. Maybe it's a future one.
So just in terms of the overall structure of the moot, you want to summarise at the start. As we said, if you're the appellant, Sometimes it might be appropriate to actually ask the judge, Your Honour, would you benefit from a summary of the facts of this case? Or you can just start off with just a couple of sentences of the essential facts. Sometimes it's nice to frame the case, especially if you're the senior counsel. Your Honour, this case essentially boils down to, or the focus of this case is, or, you know, in terms of framing it in a light that's in favour of your client, just to sort of set the scene. And that's optional, it's a stylistic thing, but I found that it works quite well for me.
It's particularly valuable as well if it's a case that's, you know, if you're representing a relatively vulnerable party or someone who's on the face of things has been wronged, but through some legal loophole, the other party is going to get away with it. Things like that can be a good way for you to build momentum and frame the case quite well. So you can say, Your Honour, this is a case about someone who has done nothing more than, and then describe what they've done. And that sort of thing can say immediately, before we actually get into the nuts and bolts of the law, it would seem intuitive that we should find in favour of your client. And so that gives you some persuasive power right from the get-go.
It's particularly persuasive for something like a criminal problem, which we have for John Hay and could be in the junior moot, where you're sort of appealing to basic morality and emotions, but still in a formal way. And then outline your key submissions at the start. So the key submissions that you've outlined in your written subs, you just want to go through them really clearly, and I mean in a really, really boring way. Your Honour, I'm going to submit this afternoon, I'm going to submit this evening on 3 key points. First, blah, 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 the appropriate test is X. Second, my client does not meet the criteria of the test. Third, important public policy considerations such as blah, blah, blah are important here because. Right, I'm now going to move to my first submission, Your Honour, and then rephrase it. Just go through it extremely methodically, because you've got to remember that this is the first time they're hearing this information, so you want to make your points extremely clear, and you want to work through it really systematically. And speak slowly, slower than I've been speaking, and pause between your submissions, especially when you're outlining them, because often they want to note them down, or the key points. And I've certainly been in situations where the judge has stopped people mid-introductory submissions and said, sorry, I just need to write this down, can you please repeat that? So they're just trying to put something that they can refer back to. Then at the end of your moot, you just want to do a nice little summary, again, reframing the case in the light you want to show it to the court and why they should find for your client. Then, just as a formality, finish with, if Your Honour has no further questions, that is the case for the appellant, or that is the case for the respondent, just to tie it all up.
Okay, so in terms of like within all that, what you're submitting, the first thing to say is it's useful to practice these submissions. So obviously the questions that you get from the judge will vary, and you won't be able to predict those perfectly. But if you have a general idea of, without interruption, what you would like to say, that will give you some confidence going into the moot, and it will mean that if the judge doesn't ask many questions, you have a plan, and it will also mean that to the extent that the judge does ask you questions, you can still always come back to some overarching structure if you start to lose your way. The other thing that's noted there that's really useful if you have time, and I would encourage you all to do this particularly for competitions, is when you're practicing that, just have your teammate asking you the questions. So you should have been preparing these together as a team for competitions especially, and so they will understand what your legal issues are, what your submissions are about, and so get them to ask you some hard questions, and that will mean that often the questions that they ask you will happen to be the obvious ones, and those will be the ones that the judge will likely ask anyway, so it will give you good practice there and preparation there, but it will also mean that you're just prepared for situations where you're a bit stumped and you can work out what you're going to do in that case, how you're going to bring it back to the key submissions you want to make, so that is really useful. So then in terms of like what you write out, it says there, write the points you wish to make in full. I think that varies though, dependent on like how confident you are as a speaker. there's nothing wrong with writing it all out in full, and that will be useful to you because it will mean that you have a very clear and methodical structure to go through. But equally, if you're someone who enjoys speaking naturally, then it is okay to roll that back a little bit and have key bullet points and sub-points as to what the types of chains of logic that you want to explain, and then speak off those. Again, because you're speaking so slowly and you're advised to speak so slowly, that can be conducive to you doing it without a fully written speech. So it's really down to, I think, your preference there and what you feel most comfortable with. But you definitely should have a structure of your argument. So which points and which sub-points you're going to make in which order, that should definitely, at a minimum, be prepared. When you're submitting, you will need to depart from your prepared speech. So the judge will ask you questions that you don't expect, or it's highly likely that they will. And they will ask you questions which may be related to a different submission that you're going to make later on. So you might be on your first submission, and they ask a question that's directly addressed by something in your second or third submission, and you just have to go with that. The judge is in control. As we said before, you're having a conversation with the judge, but it's the judge's conversation to lead. So if the judge asks you to explain something that you're going to explain later, don't say, oh, I'm coming to that later, and just go back to what you're saying. Go with the judge and let them lead you. Eventually, once they've led you and they've asked you a bunch of follow-up questions in many cases, they will then sort of nod and say, thank you, and then you can start to return to kind of the area you're at in your submissions. And the other thing to note about when you're doing that and when you're adapting on the day is that if that happens and the judge gets you to explain something that takes you a load of time that was going to be devoted to describing the same thing later in your submissions, don't then just revert back to explaining that whole thing again when you get to that point in your submissions. So flag the fact that you've already discussed it, and obviously still say the kind of basic logic of the argument, but in terms of all of the detail of that and the authorities, if you've already explained them, say, as mentioned to Your Honour previously, this is the case because, and yeah, you flag that you've already explained it to a significant extent. In terms of language, you don't want to use like hugely complex legal words. The average reasonable person should be able to sit in a room and understand what is happening in the court and what you're submitting, and judges will just think you're trying to be really smart if you use all these huge words for no particular reason. Obviously, if there is no substitute word that you could use that's more simple, then that's fine. But by and large, there will be an alternative description you can use that's more simple, so try and stick to those.
I think we're running. So might need to run a bit faster. Okay, so just easy little mistakes. Don't say Thomas J, it's just as Thomas when you're speaking. Obviously, you can write that in your written submissions as Thomas J. It's not R.V. Nelson, it's Queen and Nelson. This should be first year law, but it's easy to trip up when you're just speaking off the cuff and you're a little bit nervous. And everything you say should be backed up with case law or with secondary source commentary, but case law is really the best, or statute, and know it really well.
The one thing where that's not necessarily the case is if you're making a policy argument, so an argument as to reasons why a particular policy should be the case, that won't necessarily be backed up by authority.
No, though it is helpful if you can relate it to possibly some relevant political issue or anything like that. Alright, so responding to questions, again, it's so variable. I had my Torts Moot last week, and my normal tutor said, oh, I'll ask you, a couple of questions, but he wasn't there, so we had another one who asked us about 10 questions each. And in a space of 10 minutes, can get a bit worrying, you can get off the ball, but it's great when you can use those questions to actually put your submissions forward if you're going to get to them later, which is why don't be afraid to jump around in order to answer the judge's question, and you need to do that directly. So as we've said before, don't ever say, I will talk about that later, Your Honour, they'll probably take great offence. So always answer it directly, and when you come back to the same information in a later submission, you can kind of just gloss over it briefly and say, Your Honour, as we discussed earlier. Pausing is absolutely fine. If you need a few seconds to think about your answer, to refer to your arguments, to refer to a quotation that you've written down from a case, then do that.
It's actually even if you don't need it, it's actually advisable to do it. I found there were times in moots that I did when I would just jump straight into the answer because I'd already thought about it, and then the judge afterwards would say to me, "Oh, you should pause," and then they'd compliment the person who had paused to think about their answer, just because it signals to the judge that you are thinking about what they've actually said, you're processing it right there, and that you're not just regurgitating an answer that you've prepared before the moot. So it is advisable, just take a couple of seconds, take a sip of your water, and then respond. Yeah,
and if you do actually need a substantial 10-15 seconds to think about it, refer to your papers, make sure that you look like you're doing that, because if you sort of stare vacantly in a corner, then they will assume that you don't actually understand the question and they'll probably repeat it. So even if you were legitimately thinking about it, it can sort of throw you off a bit if they're like, counsel, would you like me to repeat that for you? So
that's the other thing, that if you don't understand the question, you can say, "I'm sorry, Your Honour, I don't quite understand your question. Are you able to repeat it, or are you able to rephrase it for me, please?"
Absolutely. And that it additionally gives you time to think. So, yes, pausing, thinking, great things. Have some water. Don't say thank you for the question. Again, did that in my first moot. Doesn't go down well. Once they've acknowledged that your answer is acceptable, then just nod and continue with your submissions unless it looks like they're going to ask you another one. Again, it doesn't matter whether you agree or disagree with what the judge has proposed in their question. You can always start with, "Yes, Your Honour, I would agree with that," or "No, Your Honour, I respectfully disagree because," but be prepared to back it up. Refer back to your previous arguments, but also be able to sort of expand and think a bit outside the box. And again, if you're trying to make a few different points in order to answer their question, it's a good idea to wrap it up with, to directly answer that question, this is the statement, yes, in some cases it may be rape even if the victim initiated it. Just to make your point extremely clear. Otherwise they could come back and question that again, and you just have to confirm it, but it's nice if you can wrap it up.
Okay, so style. Wear formal clothes, ideally. So for the torts moot, that's not that strictly enforced. I mean, don't come dressed terribly, but wear kind of smart casual stuff to the torts moot, or you can dress up even more than that. For actual competitions, you generally want to try to be wearing a suit. If you don't have a suit, wear like a shirt and tie and some smart trousers, or try and borrow a suit from a friend of yours. The speaking style, as we've said, is slow and clear. It's much slower than we've both been talking today. It's much slower than a debate. It's slower than most instances that you would have heard people speaking publicly, and it will sound unnatural initially, but invariably the mooters that go to that speed where it sounds kind of unnatural are often the ones who receive the greatest compliments from judges.
If you think you're speaking too slowly, if you think you sound a little bit dumb, then you're on the ball. That is exactly the speed you want to be going. And I've been told that my voice drops an octave when I moot. So I don't, not intentional, but it sort of reflects the slow, steady pace that you're going. You want to be able to emphasise points and make sure that the judge understands everything you say.
The other things are pretty self-explanatory. Trying to have eye contact. Torts submissions will be 10 minutes for each speaker, so 20 minutes across the two of you, but most competitions will be 20 minutes. And that sounds like a lot, but don't let that put you off getting involved, because by the time you've read, 10 different cases on a particular area of law, and you've formulated 3 or 4 different submissions, that will be a lot of content, and 10 minutes will seem like not enough. And then once you add in questions from a judge who's often enthusiastically questioning you and pressing you on the propositions you're making, that 20 minutes goes pretty quickly, so don't worry about that. And the only other thing to note there is if you finish after 15 minutes and you've made all of the points you need to make, that's fine, and that doesn't automatically lead to you being deducted marks. So don't let those times put you off. It ends up being much easier after all the preparation that you go through than it seems on face when up there.
At NZLSA, I finished all my subs for a 20-minute submission in 10 minutes, and I was crapping myself. I thought, oh my god, we've just lost the round, and then for some reason I got marked 100% because because he had no further questions, had asked everything he wanted to ask, and all had been said. So.
Yeah, and so the only other thing to note there is take control. You're in control for as long as the judge is not asking you questions. Once the judge asks you a question, they're in control. But up until then, be relatively assertive. Lead the judge until they step in and start to lead you.
Okay.
Yep.
All right. General tips: have fun, watch Suits, pretend you're Harvey Specter.
Don't actually though, because he'd be a terrible mooter in New Zealand mooting. He's way too aggressive. So.
No pinpoint references. You should probably have that noted in your written subs if it's required for what you're doing, so that the judge will have cases in front of them and they can say, sorry, counsel, what's your authority for that point? And you can say, yes, well, Justice Tipping said it in paragraph 242 of Couch. Confidence, fake it till you make it, rule for life. And again, preparation is key. Just make sure you know everything thoroughly, inside and out, back to front, and you can be questioned on it and just have a response at hand. So, in terms of Mooting Society, where we come from, the competitions we actually run are First Year Moot and John Hague Memorial Moot. AULSS runs the Junior Moot, and then there are a few faculty moots like Stout and Greg Everard, which have monetary prizes or take you on to finals on national level. We have, as we said, we have a written submission example and also the Junior Moot final from last year on the website starring me. The audio quality is pretty bad, but if you want something to just have a look at to see as an example. We will also be putting up a notification for registrars for Stout Shield, which is coming up. So that basically means... Did you want to say?
Yeah. If anyone is keen to do this, can you come up and let me take your name down now, because we're keen to get people signed up. Essentially, being a registrar is kind of managing the court in the Stout Shield competition. So the Stout Shield is the Auckland's premier mooting competition. So you'll see the best mooters from the university in that competition on some really complex and interesting legal problems. So it's really good to get exposure to those moots. And the job that you'll have to fill is relatively simple. So it's like writing, what's involved? Just writing.
You basically just time the competitors and say, all rise for judges of the court, and
you'll be told what to do though. Like that'll be explained to you before the competition. The main benefit though is that you get exposure to some really excellent mooters, and that can be really valuable for when it comes to your opportunity to do a moot. So if anyone is interested in that, please come up and let us know.
Just also any final questions. I know that some of you will have to run off to class, but they could be really useful for other people to hear. Or else you're welcome to come up to us now.
Finally, like our Facebook page.
Yeah, or sign up at uoamooting.com.
All about that social media.
That was like just...